I'm John Leonard. I'm a corporate lawyer at Fairfield and Woods in Denver, Colorado. We have a video series you can go on our website and look at. Today, we're talking with one of my colleagues, Tim Jordan, about wills and trusts and trends that are happening in that area. And well, thanks for joining us today, Tim.
Thank you.
Let's just talk real general. If somebody says, you know, you need a will or a trust, is there a difference between a will and a trust? And let's start there. What's a will and what's a trust?
I frequently get that question. There's two ways you can accomplish your estate planning in the context of how you leave your assets to a surviving spouse or ultimately to children. It can be accomplished either using the traditional last will and testament or what we call a revocable living trust. And there are some fundamental differences between those two instruments, but we generally prefer a revocable living trust as kind of the foundation for an estate plan.
Before we go there, what is a will?
So again, a will is kind of a traditional way to leave your assets to your family upon death. A will, it's a written document. And one of the features of a will is that upon your death, you're pretty much assured of having to go through probate if you have a will-based plan.
What's probate?
So that's another question I frequently get. And
I'm batting 1,000. That's good.
You are. So probate, there's usually negative connotations with the word probate, but people generally don't understand what it is. Probate occurs if somebody dies and there's an asset that's in that person's name. So, for example, if somebody dies and they own a piece of real estate, we now have a piece of real estate and the owner's deceased. So there's no mechanism for dealing with that piece of property that's in the deceased person's name. So in a will, you name your personal representative, and that's the person that you designate to have the authority over your assets upon your death. But just simply having that designation in the will does not give that personal representative the legal authority to deal with that asset. So the second step to that process is opening probate through the court. So it's a process through the courts, and we're actually pretty fortunate in Colorado that probate's a rather informal, simple process. It's not that way in a lot of other states, notably states like California, where everything tends to be more difficult. Also an important consideration is if you have real estate in more than one state, you're subject to probate in each of those states. So if you have real estate in Colorado, you're subject to Colorado probate. If you have real estate in California, you're also subject to a California probate. So that means California attorney, a Colorado attorney, and I think we all know what happens when you have multiple attorneys involved.
Would you need two wills, or would one will say a Colorado-based will could dispose of your real property in California?
It can. So your Colorado-based will would provide for how that property is distributed, but in order to actually distribute it, you would need to open a California probate. So one of the advantages of a revocable trust is we can use it to avoid probate altogether, and also, probates in other states if there's real estate in other states.
So a trust is more flexible in that respect. I do have another question about the will. We'll do another tape on trusts, I guess. So on a will, you mentioned a personal representative. Do you name more than one in case that somebody predeceases the person who dies? And if you're named, do you have to accept?
That's also a good question. So, we generally recommend that people name more than one, so that if somebody does pass away or is unable or unwilling to serve for any reason, then you have some successors already named, and you don't have to constantly come in and change your will as circumstances change.
And do I have to accept?
You don't. You can decline to serve.
Do I have liability if I accept?
You do. You are a fiduciary. So in acting in that capacity, you have to act in the best interest of the beneficiaries of the estate. So there is some potential exposure there, but part of our role is to guide a personal representative through that process so that they understand what they're doing, and so that it's done correctly, and to make sure that they're not exposing themselves to potential.
And if you write the will, do you automatically advise the personal representative then?
Generally speaking, if we do a will for somebody and they pass away, more often than not, we also handle the probate and
Okay.
estate administration.
Perfect. Well, we're spending some time with my colleague, Tim Jordan, today, talking about wills and trusts and trends in estate planning. We just did a video on wills. We're going to do our next video on trust. And of your practice, how much of your practice is wills versus trusts?
I pretty much exclusively do trust-based.
Do trust. So everything you just heard is what we used to do. But video number 2 with Tim, we'll talk about trusts and different aspects of trusts. Thanks for joining us. Please look at our website on our video series and let us know what you think. Thank you.